disturbed. A true government is that in which the citizenry of the nation is well informed. With the passage of Right to Information Act 2005, the Indian democracy assured to its people that they have got the right to get correct and right information from the government. How far it is effectively implemented in this country is the topmost question which I will emphasize. Are the governments in this country have taken necessary, adequate steps to disseminate this act to the people in this country? It's a major question mark which you have to put into it. Then, with regard to freedom of press, Article 19(1)(a) of the Indian Constitution gives this right, freedom of speech and expression. This is a guaranteed right, and freedom of the press emanates from this right that we all know. Then the next one is freedom of the privileges, 105 and 194 of the Indian Constitution. These three pillars, right to information, freedom of the press, and freedom of privileges, even after passing of about 60 years of independence, we, the people of this country, rather could not solve these unsettled questions. Are they freedom? For that, who is responsible for that? We, the people, claim for the freedom or the right to know what is going on in the forums of the or what is going on with the government. Plus, on the other side, they have got the freedom to know what is taking place in the forums of the assembly or the parliament houses. And members of our representatives, MLAs or MPs, they have got the privilege to speak what they feel fit or unfit in the forums of the houses. Where we have to draw a common line in between these three freedoms: freedom of the press, freedom of the legislatures, and freedom of the people, or rather the right of the people to know. According to me, it is not possible for a democratic nation and the elected representatives of a country to codify their privileges. Rather, they are not willing to codify these privileges. I do not want to elaborate the entire topic because we all know the cases that are with around Supreme Courts, right from self-right case onwards. There is a plea all the time and textbooks ends with the freedom of the press or freedom of privileges, codifying the privileges. Is it the solution? Is it the codification of the privileges whether it will solve the conflict between the freedom of the press and the freedom of the legislative privileges? That is my major question. Then, what would we will link with? How we will link with the right to know in this regard? The Right to Information Act gives each and every citizen of this country to get information from any agencies of the government. What is going on with that particular agency or with the government? Are they getting it? My major question with regard to these three: right to information, freedom of the press, and freedom of the privileges is that unless we the people, the press and the members of the parliament keep a restraint on themselves in exercising this freedom, then conflict situation can be reduced. That is my major contention of this paper. Simply by codifying the legislative privileges in this country, I don't think that no violation will take place of judicial, no violation will take place with regard to the freedom of the press and freedom of the legislatures and freedom of the people, which is currently under freedom under 19(1)(a). This conflict will definitely happen in the democratic polity of a nation, because people, their representatives, the press, have got their own rights to do their duty in the democratic polity by disseminating knowledge by the press. A good government is that government which assures the citizens in this country or in a country that they are well informed, rather misinformed or malinformed or not informed. This function mainly being exercised in this country by the press only. Therefore, freedom of the press can never be curtailed, even if it conflicts with 19 and 104 or 105 or 194. Then till it is codified, to solve this problem, I may say to the extent that till they are codified, if the legislatures, even if they venture to codify it, till it is codified, they must be submissive to the freedom of the legislatures must be submitted to Article 19(1)(a) or Article 21 of the Constitution, right life and personal liberty of the Indian citizens in this country. This conflict situation, right from the inception of the Indian Constitution, we see and witness day by day. Therefore, what is the solution? The main topic of this topic is with regard to freedom of the press. My question is, what is wrong in it in reporting what is happening in the 4 hours of the legislative houses or in the parliament? Because they are the elected representatives of we the people. If we are supreme, the privileges are attached above to 19(1)(a). Is it not better for the nation to assure the people of this country, guaranteeing the freedom guaranteed under Article 19(1)(a) or Article 21 of this the Constitution, that you are free to exercise it, but reasonable restrictions are always there. But you keep a restriction on the freedoms which we have called upon to exercise. While exercising freedom, keep a restriction upon it. What is wrong with it if a press is reporting a matter which is taking place in the forums of the legislative houses of the parliament? Are they not free? At this very same time, are the members of the legislative houses of the parliament, are they not free to exercise their right to speak or to exercise their freedom in the forums of? They are also totally free. What is wrong in it? What is wrong in there is nothing wrong in it. Or so also there is nothing wrong if it is reported by the press, because we have got the right to know about it. Because we are electing it. They are enjoying certain privileges. Then how I am linking with the Right to Information Act 2005. Suppose if an ordinary citizen in this country is applying for what our elected representative has spoken today in the House of the Parliament, is he not entitled to get, or has he got a right to know what my elected representative has spoken in the Parliament about this particular topic? We have enough number of freedoms. Therefore, these three freedoms, right to know, freedom of the press, and legislative privileges, must prevail in this country, and they must have their own freedom. But only thing which I emphasize is that we the people, the press, and the members of the legislative houses, when they exercise their respective rights, they must always remember within their mind about the reasonable restriction clause which is attached to the privileges or the freedoms which are guaranteed under the Indian Constitution. Thereby, only the democratic polity of the nation can be made successful. Definitely, true democracy in this country will survive and flourish and will cherish. With these words, I conclude. Thank you.
And necessity of codifying the laws so that may be reduced or minimized to a greater extent. Now I request Mr. P.K. Jayakrishnan, is advocate in the Supreme Court, to Mr. Shiva Kumar, Professor Shiva Kumar. Professor Shiva Kumar, he is research professor in Indian Law Institute.
Rajesh Agarwala, Mr. Jeremy Dane QC, then Professor David D. Peck from Birmingham University, Dr. Georgios, other my colleagues, friends, senior bureaucrats, ladies and gentlemen. My topic is the role of media in a democracy. Dr. Georgios has already dealt with the statutory provision and restriction, what is the need for this. But I thought I start with a quotation and end with the same person's quotation. Whether it is relevant or not, that you can discuss and you can come to a conclusion. I am quoting a doyen of Indian legal provisions, Palkiwala. He observed, freedom of press is, freedom is to the press what oxygen is to the human beings. It is essential condition of its survival. To talk of a democracy without a free press is a contradiction in terms. A press is not an optional extra in a democracy. I think very beautifully he narrated the entire scenario in 3 sentences. Because we are discussing in an international context, I want to summarize into this press law or freedom of press or media freedom. We are having 3 constitutional contexts. The first one is where there is no written constitution, yet the host of statutes delimit the freedom. You know that one. It is a situation where UK holds. Then the second context is where reasonable restrictions are permitted to impose by the Constitution itself, and the court is called upon to decide whether the restriction is reasonable or not. As you know, in the Indian situation. The third context, of course, is American. Everybody knows the written constitution guarantees freedom of expression without any limitation, but the court may impose restrictions. These are the 3 contexts, constitutional contexts in the world the press is governed. Apart from this, there are some countries there is no freedom. The dictator or the ruler will decide what is press freedom, is there any press or not. I am not going into that. If we are legally discussing, these are the 3 constitutional contexts in India. That's why here then I want to inform the Indian context. Indian judiciary, we can say this is an example for reasonable restrictions are permitted to impose by the Constitution itself, and court is called upon to decide whether the particular restriction is reasonable or not.